Welcome back, everyone. I think, right? We're here. We're good. So we're going to do some quick administrative matters, hear from staff about pending bills and crime rates, and then discuss the idea we heard this morning and from previous meetings. After that, we'll take some public comment and make some final recommendations for 2025 report. I'm noticing I'm having some lag on my video, so I'm going to go on and off video for a bit. But Tom, well, I'm going to move to approve the minutes. Does anybody oppose? Okay, the minutes are adopted. So I'm going to hand it over to Tom now to talk about pending bills and crime rates. I'm going to try to fix my camera. Apologies.
Yeah, great, no problem. There's a lot to get through. Legislative update. This is quick. So the legislative session essentially ended a few weeks ago. There's one bill based on committee recommendations or otherwise supported, AB 1036, that got through. That's awaiting action by the governor. This has to do with post-conviction discovery. It was related to the wrongful conviction and innocence topics we looked at last year. And there's a few more that are still alive in one form or another, and there could be action on them. Well, there would need to be action on them early next year, essentially. And that's AB 1231, which is a diversion and low-level felony cases, and then SB 560, which has to do with benefit overpayment prosecution, sometimes called welfare fraud, and SB 277, which is consent searches. So we'll, we work very closely with Natasha Minsker to help these bills get over the various requirements, and we'll continue to do that. And it's a very tough year for bills of this nature, but if 1036 would be a great one to get done. All right, crime rates. So we're able to look at just violent crime data, just the 8 largest jurisdictions in California, which includes the LAPD, Los Angeles Police Department, and the LA Sheriff's Department, which is a lot of smaller cities in LA County. And then we can compare it to the rest of the country. So we can go through June. Overall violent crime down 12.5% compared to the same period in 2024, where it was down from the year previous. So we're seeing a return to those extremely low crime rates that we saw before COVID on violent crime. That's overall violent crime rate. And we can see the individual offenses here, a 20% drop in homicide, 15% drop in rape, 19% drop in reported robberies, and a 9% drop in aggravated assault. Outside of California, we see very similar numbers, slightly larger in California. And just in the jurisdictions in LA County, which again is LAPD, the sheriff, and Long Beach, we see very similar drops, but everything down, which is a really good thing to see. And we'll try to, update this with more data as we get it. All right, so those are those quick little updates. We're now going to move to follow up from the last few meetings we have, and we're going to start with the July meeting, which is about the Racial Justice Act. And Joy has been leading our work here, and we have a number of proposals for the committee to consider and some other updates. So feel free to interrupt me as we go through these. And if I don't hear interruptions, I'll assume everything looks good. Okay, the first thing we want to talk about was 2 ideas that came up at the last meeting that after further research, we decided not to pursue. The first is giving guidance on protective orders over data and information that's disclosed in a Racial Justice Act case. We heard a little bit from some panelists that these are overprotective, overbroad, and they're preventing other people from using some of the data information that might be relevant in other cases. Unfortunately, we weren't able to really find sufficient information on our own to figure out what would make sense as a helpful recommendation there. So we don't think we should move on this.
I don't even recall. There's protective order on the disclosure because people were concerned that the data would be too much data would be released into the public.
I think it was less released to the public and more shared between defendants in the same county. But we weren't quite able to find where is this happening, what do these orders look like, are there other reasons for it?
I think my position, I'm just, for whatever it's worth, it appears we're not pursuing this, but this seems to be public information to begin with, I think. So, fine.
Well, if it's what prosecutors, I think, are generally people seeking these would say, well, this is information you got through a motion, an order that a judge made in the context of an RJA action. So maybe some of it would be otherwise attainable, maybe some of it wouldn't. But and I think sometimes there's police reports with victim's name and things like that. So we just weren't able to quite figure out where is the problem here, how widespread is it, et cetera. But it came up last time, so we just wanted to check back in about it. Okay. The other thing that we discussed a little bit last time was this idea of prosecutors being required to give notice to defendants of favorable RJA rulings. And it turns out the committee made this recommendation last year, essentially in 2024, in the context of recommending that prosecutors should have to disclose any favorable evidence after conviction. And we specifically said that should include RJA rulings. So we concluded that recommendation was made. And that recommendation was the basis of the bill I just mentioned from Assemblymember Schultz, AB 1036. And so that might go away to doing this. It doesn't specifically mention the RJA in there, but it does say favorable evidence, not just exculpatory. So we'll kind of have to see how that plays out a little bit. Okay, so those are the things we decided didn't make sense to pursue at this time. And the last little bit on this is there's a RJA bill from Assemblymember Kalra that passed through the legislature. It's called AB 1071. It's awaiting governor's signature, veto, or other action. And if that doesn't finish, we may come back and say, actually, there's 2 or 3 ideas there that would make sense to include in our recommendations. So we just wanted to flag that. Hopefully that bill will be signed, but if it isn't, we might come back to the well. We might see some stuff on the report based on that, but we'll talk about all that in November if we get there.
And what can you just give us quickly what the bill is about?
It's mostly about procedures, about, I think, just clearing up some of the threshold issues that have come about, and is this a habeas corpus motion? Is it a new motion? And getting counsel assigned and things like that. It covered a lot of procedural things. Joy, I don't know if there's anything you want to add to that, but
I'd love to see it, or if somebody could send me the bill number.
AB 1071.
There it is. There we go. Okay.
Yeah. All right, so let's move on. One last sort of research update. So we'd also discussed last time, and staff had proposed that we sort of partner with researchers, including folks at the California Policy Lab, to come up with a guide for judges and how to think about statistical claims. So to work with Steve Raphael and other folks there, who have really thought about these issues for a while, and to sort of create something that's a resource for courts when they look at these claims. So we've started organizing this. And it looks like we're going to be able to include experts from Stanford Law School, in particular, John Donahue, who wrote a big report about statistical analysis of the death penalty in Connecticut that led to some pretty big changes there. So there's a lot of affinity with what the RJA has done. And we also hope it will sort of incorporate how the statistics works in other legal claims like employment discrimination and things like that. So this is something we've started organizing and we'll continue to report back, but this will be on a different timeline than our annual report, which we're going to have ready for you all next month. Will be out this year. I'm thinking that this sort of standalone thing will be ready, mid 2026. So I want to update you all about that. Okay, so now we have the proposals, and we've got 5 to go over, but don't worry, 1 is a rehash from before, so it's really 4 new proposals. The first has to do with reducing duplicative litigation at the prima facie stage of the RJA. So this arose from our discussions around sort of maybe there might be some lessons from class actions or other legal vehicles that sort of consolidate similar claims. Not typically something that comes up in the criminal context because everything is so fact specific, but we did, and it's all detailed in the memo, find some good precedent. And what we boiled this down to is saying that once a judge has made a determination on a prima facie case, that should be presumptively binding on other courts for similarly situated defendants using the same data. So essentially, defendant A gets a ruling, defendant B, who has the same argument, shouldn't have to go back and sort of do all that work over again. So you wouldn't have to, hopefully you wouldn't have to have an expert at that early stage, including for the prosecutor, and it would hopefully allow these cases to proceed to the merits a little more quickly. And this would apply to both defendants and prosecutors. So prosecutors also wouldn't have to relitigate these claims if it is the same again. And some guidance on how to overcome the presumption would be, you'd say, obviously, this actually isn't similarly situated. Prior counsel was inadequate for whatever reason, or there's new or different data we have
Yeah,
here that
I
changes
I
it.
actually have some reservations about this for precisely that reason. I mean, I understand the logic of it, and if everybody was acting in good, really on equal footing, but especially in large counties, I'm just seeing, RJA claims being denied all over the place. And then for a prosecutor to then walk in and say, RJA claim has been denied, we presumptively get to deny yours. And then you put a lot of defendants behind a double eight ball.
Mhm.
And I think that this is the intention here is to make it actually easier for incarcerated folks or defendants to prevail in RJA claims. But if I had to guess, I think it would be the outcome would be the opposite. I don't know if anybody has different feelings about that.
I think this is, if I remember correctly, this is getting at the same issue that we rejected a few slides before, which is the onerousness of collecting all the data and sorting through all the statistical data. I mean, this says findings instead of data. I don't know how much findings on the same statistical data can vary, like either statistical data bears out, a disparity or it doesn't. But I think it circles back to the same problem that every person putting forth an RJA claim is tasked with collecting the data, analyzing the data, running the statistics and making their case. So, just an observation. I think that is one of the big stumbling blocks for RJA. And I don't know that either one of our proposals exactly gets to the heart of what is making it so difficult for people on the disparity cases.
I know how I know. I mean, I can tell you some of that, but I'm curious. Maybe there's some middle ground here where all data that's filed in RJA cases become public, so then everybody can use it rather than just
Mhm.
We could define it in a way that didn't involve privacy concerns, statistical data related to these things, not including victim names or whatever the little privacy concerns are. I don't think there's a lot of privacy concerns to this disparity driven data, but I'm not,
well.
I haven't done one of these cases. So
One of the RJA prongs is this is a race to the victim. So, you could get into that problem, but I think that those are going to be
you wouldn't need the race of a particular, oh, I see. I
right.
see.
You get an RJA claim if there's a disparity based on the
Right,
victim.
but the data from one case with the victim of the victim's race in one case doesn't matter to the person in the other, but these big disparity groups of data
Right.
should be easily and readily and publicly available, whether or not the courts can make the same different findings based on the same data. That's why I went to law school and I didn't go do something in the math world, but I would think not. I would hope not. I don't know. So then, but the fact that this is findings instead of data, maybe that's the crux of your concern, Mike. And maybe if we did find a way
My crux of my concern is that lots of people are filing these all over the place, right? And they're saying, from prison, and they're saying black people in San Diego County get disproportionately long burglary sentences. And then the court says, no prima facie case here because you didn't submit anything, right? Because they're in prison. And then somebody who actually has a case and actually has the data comes in to San Diego, now faces a double burden because there's been this prior case that says no prima facie case of racial disproportionality against black defendants in San Diego County, but because it was filed.
but they'd be using different statistical data in those cases that you're positing. And this proposal is
Well, but Tom, you're suggesting that once a finding of disproportionality or not of, um, let's say, black defendants in San Diego County convicted of burglary, that would kind of apply throughout the county.
Right. Unless you can say, well, that last case was pro se, and now it's now I'm counseled. I have experts. That's a reason, or I think
I,
you
I,
just
I,
don't want literally the same.
I get that, but I'm going to tell you, I'm going to be up against 10 of these rulings from 10 pro se people and judges are going to be like, well, you didn't overcome your presumption. Yours, that's the, like I'm very,
Those
I'm,
people
Yeah.
don't have the data. Are you saying they would have the data?
no, they don't have the data. That's my whole point. And we would say we have the data, so we should overcome the presumption. And the judge says you don't overcome the presumption because it's not enough data or whatever. It just
Mhm.
makes it one extra hurdle for us to get over.
I mean, I
Which
think
is,
the language using the
Mhm.
same statistical data is pretty clear. Like if someone's getting, there's no prima facie on a case with no data, and then they're coming with data that's not the same statistical data.
well, I would want to wordsmith it very carefully because I just feel like these cases, not even the relief that we're asking, just the intermediate step of getting a prima facie case in discovery is a tremendous burden on the entire system that nobody really wants to grant. So there's inertia against granting these to begin with. They're hard to prove even in the best case scenario. And then to add this extra burden, which I think would actually fall more on defendants.
Mhm.
um, uh, I think you're trying to get the opposite is if a defendant happens to miraculously marshal enough evidence to prove that Black people in San Diego County do receive disproportionately long sentences, that should be able to be used by the next Black guy sitting next to him, also charged with burglary. That makes perfect sense. I don't know. Because 9 out of 10 or 99 out of 100 of these RJA claims have been dismissed already for not making a prima facie case.
I think I mostly agree with Mike. I don't think the proposal should be related to court findings. I think there should be a way for everyone to have access to the data that is collected by others. Because you may need two different data sets and manipulate them to get your specific situation, something that's representative for you. But the problem for everyone is access to the data and experts to analyze the data. And I'll stop talking.
I agree. Mary?
I was just going to say too, again, I didn't like Heidi went to law school instead of some sort of math school, but it would seem that the statistical data would have to be, I would just want that defined narrowly enough that it's really specific to like the time frame or the year, or maybe even a particular DA within an office. Because I just feel like if, like your example of burglary suspects in San Diego, if there's a changeover in supervisors in a DA's office, that could change on what pleas they're allowing their deputies to take. And so you'd want it. So I just want to make sure that the same statistical data really means from a very narrow area.
And judges have also not gone to math school, so to ask them to say like, oh, well, that's statistically significant in this case, but not in your, I just think we're running into it. I like the idea, at least, of making all data filed in RJA cases public.
So, I mean, one thing we could do, we could say this is only the defendant could take advantage of this presumption. I think that opens up a lot of other issues. And I think, but I'm making the data accessible. So so if this data is like an Excel spreadsheet, how would you share that with a pro se defendant in prison? If that's what we're worried about.
The public defender gets it. That's their responsibility. I know.
Public defenders will say emphatically that is not our responsibility.
Well,
and
I emphatically disagree. I'm sorry to interrupt. I emphatically disagree.
Right.
Public defenders, throughout all of these post-conviction proceedings, they've said for 20 years that they don't represent people who are in prison anymore, and no, they still do.
But that limits people who are conflicted out of public defender representation. I mean, I don't know exactly what the mechanism is, but it doesn't, once a data set has been created, it should be, maybe there's a public page where it says, we have a data set for everyone between these years, this crime, these races, or something like that, and you can request it. I don't know exactly what but there's got to be a mechanism. There's only a few agencies who can provide the data, so we know what's being provided to various people.
Well, at risk of stepping on my own toes, we are in the process of trying to publish a great deal of this data for free from Stanford to make this accessible, again, not to people in prison because they don't have computers that can run Excel, but to public defenders and everybody else actually in the country. If we could phrase it, Tom, in such a way that a finding of a prima facie case of racially discriminated practices shall bind this county, therefore only, benefiting petitioners, I'm for that. But the other, I think I would,
Hmm.
unless I'm very concerned.
Well, maybe we should not force this issue because this was motivated on my and Joy's part, I guess, by this idea of like built into the RJA is this idea that we can find similar situated groups of people and speak about them as a group. Like that's one of the elements of proving your claim. And it seems like if we're doing that, there should also be some efficiency benefits to that. That if we are saying we can do that, we should be able to not have to then have every defendant who's similarly situated start from scratch in each case. And
I
again, we just
agree
haven't
with
figured out how
that.
to do it.
I agree with that. I think we need to figure out a way to do it.
Yeah.
But if Mike is, putting something public out, like you could also imagine that wherever this data is publicly available, it's, there's a finding that someone who's African American and committed an armed robbery in Humboldt County between these years, you can publish the decisions or the court findings for people to use. I don't know. I mean, there's so
Right.
many parameters and there's so many variations. That's part of the problem with the law in the first place, but it doesn't mean we can't find a way. There should be a way to do that. But I agree, no one should be having to recreate this from scratch. It's an impossible task. I think that's why we haven't had many cases, because we know it exists, but no one's been able to prove it, even with the best lawyers. So once people do start getting enough data to make the case, we should find a way to either share that with everyone who's similarly situated, just the way maybe you send out, the DA's office is required to send out letters when some Brady or, something comes up. My clients get letters like this, the lead detective in your case is this and this and that. And maybe there's some kind of notification requirement, but it's complicated. It's complicated, but I think it's got to be on the providing the information, whether that's the strict data sets or that's the findings by the courts where there are disparities, and not trying to control the findings of the court.
Yeah, I think we all sort of agree. I'm just worried about the
Mhm.
unintended consequence here, which I think actually will be significant. We're, pursuing these cases right now, and I can see it just coming in my face. I would say that if a court finds that if a that somebody's entitled to relief under the RJA for disproportionate punishment, in other words, there's racist sentencing in this particular circumstance, that should be, if not, that almost should be binding. That finding
Mhm.
should be binding. A finding that says, well, we don't have sufficient evidence of racism, I don't think that should be binding at all. But once a court says, yes, it's more likely than not that the sentences for burglary in San Diego County between such and such a dates were racially biased. That I think that should stand, and I think that can be differentiated from a mere finding of insufficient evidence, which should not be binding or should not have any.
I think we should also spend a little bit of time considering if that's going to dissuade courts from making those findings because it's going to have such broad impact.
They're going to be dissuaded anyway. We're asking for millions and millions and millions of data points in big counties. We're going to be getting. It's a heavy lift already. But I hear what you're saying.
What and Mike, I think in that scenario, because one thing we thought about this too is, well, what effect will like an appellate decision have on this? Because if there is a ultimate decision on the merits like you're describing, Mike, presumably that would be appealed because but then if it isn't, but it's almost better not to appeal it because maybe only one defendant gets the benefit. I mean, but if it is appealed and affirmed, that it almost is sort of like you can't
No, if it is
It almost
appealed,
becomes, it's the law, I mean, it's like a mixed law and fact question. I mean, I don't know, but
No,
no case has actually been appealed and had a decision yet. So we're a little bit ahead of the state of the art, which, we're trying to think ahead, but maybe it just, we're just still stumbling around the darkness too much.
I think that well, I agree that a published appellate decision, and you're right that they may not appeal for precisely the reason that you're saying. But I think that if a judge in a county finds that racist sentencing practice in that county, that should somehow have some kind of weight on other judges in that county. I think a judge who merely says there's not enough evidence here, that should not have any precedential value or any.
But then defendant comes in with the exact same filing, puts his name on it or her name on it, files it with another judge. 10 more people do that, like literally like carbon copy,
Yeah,
which has been known to happen.
of course. So you're saying that if it's a winner or if it's a loser?
If it's a loser.
Yeah, if it's a loser, so then the court keeps on denying them. Yeah, there's
Right.
insufficient evidence. That's what's going on today. And I'm telling you,
Yeah.
every county, they already have a stack of denials. So
I wonder, sort of like legal tradition kind of creates that presumption a little bit. If you actually do have, if the court says, yes, I'm finding, disparities in all these burglary convictions, if the next person come and say, look, your buddy next door already found this, you're really going to disagree and throw it out. I wonder if that kind of happens naturally. I don't know. I would love to hear from Judge Espinoza, as always, all these questions about how judges think.
I've been asking myself, listening to this conversation and barely understanding the math pieces, because again, I was promised there would be no math, which is why I went to law school. But I'm still struggling with the idea, and you've just raised it, Tom, that because the judge next door made a finding, that it's binding on me. And it may be that I just don't understand the RJA well enough, but I look at a county like Los Angeles with 280 judges hearing criminal cases, and the view of criminal justice in Los Angeles County runs the political spectrum of, I just have a hard time with the whole idea, which is why I haven't said anything. I've just sort of been listening.
Right.
I share Judge Espinoza's assessment of Los Angeles County, and it's particularly where I'm most concerned about. Why not a statute that says if a judge finds racism, which is what the RJA says, meaning a racially disproportionate sentencing in certain circumstances, that shall be presumptively binding on superior courts in that county who face similar cases, and leave the other stuff blank, because those are just merely insufficient evidences. Those are not an affirmative finding of lack of racism.
Well, so one reason we focused on the prima facie and the statistics element is that at the evidentiary hearing, the DA does have the chance to come in and explain why there are race neutral reasons justifying what happened in this case. So it does get, the further along you get, the more individualized it gets. We were trying to isolate the part that seemed the most generalizable to other people, and would also help, cases proceed the most. And once you do have an ultimate ruling, I think then these issues around, well, it'll get appealed, and it seems less helpful.
I'm not talking about ultimate ruling. I'm saying once a judge finds a prima facie case, means they're reasonable.
Okay, I didn't hear you say the prima facie part. You were saying once the judge finds racist sentencing, which is different than the prima facie case.
Okay, once a judge finds a reasonable probability of racism, that should be enough.
To bind all other judges in that jurisdiction?
Not necessarily bind, but have a presumption that, okay, in a similar situation, we're going to presumptively also see that there's racism unless you prove other. We're going to bounce that directly to the DA and say, why not? And the other way around is just too hard, because all of the other findings are just insufficient evidence. It's just, and we're going to lose.
And does this ultimately help? Because then you just have another fight. Well, here's how the case is different. And so the presumption doesn't apply. Okay, now we start over again. And does it ultimately help? I think it It could, but the more we talk about it, I'm less confident that we've cracked the code. And we haven't quite seen, I think, how, if this argument about like courts weighing what is literally the same or very similar evidence and reaching different conclusions, you know, Judge A Monday, Judge B on Friday, how that will be resolved if it actually comes up, because that just doesn't seem appropriate, you know, because it's not supposed to be different if you're looking at the same data, kind of like you were saying, Heidi. I don't know.
That's why we have appellate courts, but stay tuned. I mean, we're gonna
Right.
test that.
I mean, I don't think we should force this, because if we do something, I think we would want to feel very confident about something like this because of the sort of domino effect it could have in particularly large counties. But obviously, whatever the committee wants to do, we'll execute. But that's my take on it right now.
My current thinking is that I would recommend, number one, all data become public. Somehow the court has to make that public. And number two, a finding of a reasonable probability of racism, meaning prima facie case, that shall be presumptively not fully binding, but should be presumptive, the starting place in any similar case. And if the DA wants to come and say it's not a similar case or overcome the presumption, that's just fine. But I don't want a finding of lack of evidence to create a presumption against any petitioner.
Mm-hmm.
I think that's similarly problematic. I go back to my let's just find a way to make sure everyone has the data so that when they go in with their case, they can present the data to the court and let each court make its determination. But I don't know, it's complicated.
I mean, there is a lot of data available already. I feel like the problem is we still don't quite know what you need to prove to make a prima facie case. So it's a little bit, makes it difficult to evaluate what data needs to be available. It's kind of a chicken or the egg or whatever metaphor you want to use.
Why not at minimum I mean, everything that's filed in court is public, right? Why not we just, because we are all saying the data is part of the problem, that courts just take sort of responsibility for just.
Well, what I've seen actually filed is a declaration from an expert saying, I've reviewed this data set and here's what it shows. And the actual data is not part of the court submission.
Yeah, that's true.
So we're kind of creating something that courts will hate. And B, how do you, and we'll have a cost to it. And C, I think if somebody wants that data, they should just go to the defendant, you know, like, it's not, you know, I don't know. I think the problem is we don't quite know there's still so much uncertainty about what exactly data you need and what it needs to show. So we were trying to sort of just not get into that and just say, whatever it is, it doesn't have to be determined 15 different times. But I think, I'll just repeat what I said. I think we shouldn't force ourselves to make a recommendation in this area.
These were all, sorry, but these were all very similar discussions that we had when this legislation was going through.
Right.
Like exactly what are they going to need? And we couldn't come up with anything that we could recommend, and it was moving swiftly. So it was, yeah, it's all very much the kinds of questions we internally raised amongst ourselves.
I will say, you know, in defense of the RJA, I know that there has been very little justice ultimately meted out under the statute. It is an excellent piece of legislation, and I believe that there will be soon significant findings, and I think I think in the long run it's going to turn out to be, we're going to be all proud of it.
All right, with that said, should we move on and just sort of X this one out for now? I mean, we'll keep thinking about it. Maybe one of us wake up in the middle of the night with the perfect idea, but until then, let's keep moving. All right, so number 2 actually, I think kind of works well with that discussion. So this would be expanding a court's power to appoint referees in RJA cases. A referee is what we call a special master in, California state law. So right now, the RJA says the court can appoint an independent expert, but only at an evidentiary hearing. We would suggest allow a court to appoint a referee who I think has a bit more power than just an expert at any stage. So at the prima facie stage, help manage discovery to sort of deal with, I think, some of the statistical or data issues earlier on the court's discretion. And maybe even you could appoint multiple referees. So you can imagine like a retired judge and maybe a PhD who could work together. They might have some special interest. And just as a way to sort of maybe unblock some of the hesitation that it appears some courts are having and engaging directly on these issues. All right, great. The first one always has the most discussion, and then it's easy. That's what we've learned after 5+ years. So this is a totally new recommendation that we didn't discuss last time, because about a week after the July meeting, a published appellate court decision called En Re Huerta came out that said RJA does not apply to gang enhancements. Now, this was a case that was originally filed pro se. No, I mean, it had counsel on appeal, but it started that way. And neither side of the case had raised this as an issue. Obviously, the defendant didn't raise it, but neither did the attorney general, something the court reached sua sponte. And it appears to conflict with what other courts have done, including the California Supreme Court. So we would just say, let's just say that is totally wrong, has always been wrong, and special circumstances, alternate sentencing schemes, whatever you can think of that has to actually go to a sentence would apply. So
Is there any reason why we can't also just say that across the board, that all of these things are the same thing? Because courts have always parsed them out, always to the detriment of defendants, frankly, to say like, that's not a sentence, that's a special sentencing scheme. That's not a sentence, that's an enhancement. That's an enhancement, not a sentence. It's just like a shell game.
I think we could, but I think we'd actually want to be kind of quite careful, because that might have some unintended impacts everywhere that those terms are used throughout the law.
Sure, I hear that. I'd like to think about that perhaps for next year, but at least my understanding is that the court said, you challenged under the RJA the gang enhancement, but the RJA never says the word enhancement. It only says the word sentence, and therefore, because it's you're serving an enhancement, not a sentence. I mean,
well, it allows you to challenge the sentence for an offense, and the enhancement isn't the offense. I agree. I don't think it's the most well-reasoned case, but
no, it's perfectly well-reasoned. No, I'm serious. I mean, I think they know exactly what they're doing.
I think we're disagreeing about what well-reasoned means, but yes, or we're having a fake disagreement.
Yes, exactly.
But anyway, I think it's very straightforward and just one of these things where it's almost just a statement of legislative intent, because the RJA itself in the very long findings preceding the original passage talks about sentencing, not about just the offense. So it seems certainly inconsistent with the spirit. All right. This proposal number 4 here is to re-up what we said in the 2023 report about data access, particularly about data that is publicly accessible or that people can get before they file a claim. So there's sort of 3 prongs to it. The first is to require more information and reports that DOJ, CDCR, and Judicial Council already put out. They put out great information, but it just isn't specific enough for RJA purposes, and they have it in many respects. The second is to allow people who are investigating an RJA claim to get probation and police reports. There's there's very narrow windows to currently get these, and we would say, it shouldn't be so harshly interpreted for RJA claims. And the last is to fund the Prosecutor Data Act from a few years ago. That would be a phenomenal, best prosecutor data system in the country, probably, and certainly the biggest, but it was passed with the provision doesn't go into effect unless it's funded, which is not going to happen anytime soon, probably, but nonetheless, it's super important. It would actually solve a lot of these data problems. But
I think I support it. I think that there's not much objection to it. However, I don't want our report or even us to say that the publicly available data is not able to there's no publicly available data that will be helpful in an RJA case. I would never want to walk into court for somebody and use publicly available data and for the judge to say, I just read the committee's report and it says there's no publicly available data that's useful in an RJA case.
Yes, no, I certainly wouldn't frame it that way. And this is mostly about, I think, data that the agencies would put out on their own that would be available for people to use, and not necessarily stuff that you could the public can request, if that distinction makes
I guess,
sense.
but even the slide gives me pause.
Well, I mean, I think, again, it goes back to this question of what exactly is needed for a prima facie case. And it might be that
No, we need more data. I just don't want us to making affirmative statements that publicly available data does not have the depth required to be helpful in any RJA case. I mean, that's
okay, right.
Action.
Right. That we were trying to save space on the slide. That's a good point. That's not, we weren't trying to be tricky there.
That's what I mean.
I would say often does not, whatever. I take your point. Okay. Yes. Last one, strengthen appellate review of RJA claims. So the RJA was amended to say you can bring a claim on direct appeal about, so this is the non-statistical claims, about biased courtroom language if it's apparent from the record, e.g. in the transcript, even if it wasn't, exactly properly preserved as you would want it to be, and appellate courts have generally rejected that. And there was also a stay and remand process where you could request an opportunity to go back and develop the record, and that's also been made very hard to do. And so we suggest just strengthening those provisions that are already in the RJA, and I think had an intent to be stronger than they have ended up being interpreted. So pretty wonky procedural thing, but helps further the goal of the RJA of eradicating racism. You shouldn't have these preservation rules getting in the way of that if you have a really obvious claim. All right, so those are our RJA proposals. We handled those as a group. Now we're going to go back to some of the other things we talked about before the RJA, mainly gender bias and the blanket disqualifications. But before we do that, a few updates on coercion and the coercion defense that we've talked about, and these new BPH regulations that BPH has put out about investigating people for possible clemency referral or to go back to court for resentencing. So I'll start with those because this is something we've been tracking a long time. There's been a lot of progress. The regulations are actually out. They came out last month. They're in public, or in August. They're in public comment now through October. I know many of you are very involved in this, but just to have basic info, the eligibility is basically you've served 25 years in prison. Credits don't count towards that. People who are excluded are, capital defendants, anyone with a PC 290 offense, I think current or past, so that's a lot of people. And then those people who are going to get out basically within 3 years or have the chance to get out within 3 years. The actual review process is very similar to the current parole hearing process, the same standard, which the committee has criticized in the past, but the unreasonable risk of danger to public safety standard. And if you go through all that process and you're referred, you get sent to both the governor's office and to court for resentencing. And once sent to court, you get a presumption in favor of resentencing, you get counsel assigned, and the court has to at least have an initial status within 30 days. And that's all thanks to recommendations that we made in the past and were enacted into law. So I think implicit in this is it applies to people with life without parole sentences, unless otherwise excluded. Yes, Heidi.
I think the committee's recommendation on this predates my membership on the committee, but I'm assuming, or I'm curious whether the committee recommended that PC 290 registrants be excluded from consideration.
I don't think so. I think we just
very recently added to the conversation, anyway. Is it appropriate for the committee to discuss that or take a position on that, or not appropriate?
We've never quite dealt with a situation like this, so we can figure it out.
Are we? Let me ask this: are we in the notice and comment period now?
Yes.
How and when does it end?
21st
of October.
Yes.
So Heidi, are you suggesting that we, and I would consider this as a committee, writing, making a public comment?
Yeah, I guess that is what I'm suggesting. I guess that is what I'm suggesting.
And the public comment would be essentially we're okay with this except for the 290 registration, or is there other issues that you have?
That's my big issue. I'm still looking at it and thinking about public comments from an organizational perspective, but certainly I think that's the big sort of, I don't know, it just doesn't square with me. Like the Board of Parole hearings is in the risk assessment business, not in the culpability determination business. And this feels very much like a culpability determination to just completely exclude people, you know. So I think it's problematic. I would love for the committee to discuss it and weigh in on that exclusion, if nothing else.
Okay,
The-
let's think, can we do that right now, Tom?
We certainly have a quorum. I'm a little, I don't think we've ever quite had a statement from the committee like this with less than everyone weighing in. There's nothing stopping us from doing it, but the fact that we're missing, you know, 3 of the 7 folks gives me a little hesitation. And I also suspect it's just purely a political, like PC 290 people are going to be excluded no matter what. And it's a regulation, so it's much easier to change than a, you know, a statute. So that's my hesitation a little bit. And I guess we could try to reconvene everybody. We need 10 days notice to do that, et cetera, et cetera.
No, we don't have time to do that. All right, this is a matter of protocol. Heidi and Peter and Mary, if we could, the 4 of us today, right now, craft a short recommendation. I'm not saying that we could agree. Do we feel like it's even fair to do to the other members of the committee who are not here? I'd like to hear everybody's thoughts on that.
Yeah, this is Espinosa. You know, probably not fair to everyone because particularly the electeds, because this is going to be somewhat controversial, it would seem to me. Shouldn't be, but it could be. You
Fair
know,
point.
and my question is, I know you're not asking for my question, but is the commitment offense the offense that requires 290 registration?
I think it's any.
Any.
Just
like-
so broad because
And this is going,
things
this is
you can
all,
get, the things
Yeah.
you can be required to register for, run the gamut. And I don't think should be included in a broad stroke like this. But that having been said, I think we should have a close to full contingency here.
I hear that. And everybody should remember too, that this only gets people to the parole board first, number 1. And then if you go through the parole board, then you either have to run the gauntlet at the governor's office or through court. So there's a number of screens before, it's not letting all 290 registrants willy-nilly out of prison. Mary and Heidi, how do you feel about?
Well, I was
go-
going to say, I think Senator Weiner might be sensitive because he's been attacked on some of the 290 stuff in the past because of some of his legislation. I don't know where he'd be on this in particularly because I do think he has people, but a few of the bills he's done that are sex offense related have
Right.
opened him up to attack. And I just don't, but on the other hand, he might be okay with the idea that, you know, it is all these steps. And so I just don't know how public it would be attributed to him
Well,
politically.
putting him as aside, I mean, but it's essentially what Judge Espinosa, what Peter was saying.
Right.
Do you think that it's fair this committee, I mean, he, you know, obviously we all know that Senator Weiner could have shown up. He hasn't. I don't want to force it down his throat, but I mean, this is important. It's time sensitive.
I don't know enough to know whether it's fair or not. I mean, I think it's fine. I just don't know. I don't know the sensibilities of the other people or how fair it is. And I guess if you're not showing up, anybody who doesn't show up is, you know, you're subject to potentially something being decided that you didn't agree to, but I don't.
Heidi, what do you think?
Yeah.
Oh, were the other members on the committee when the committee made the recommendation for the clemency regulations that did not include this exclusion? Or
No.
No?
Neither of them, neither. No.
Professor Ocean may have been, but
All right. Is there a way,
We do everything else with a quorum, you know, We do everything else with the quorum. I don't want to circumvent the process. I would much rather it be an inclusive process if we're going to do it, but I don't.
Of course. Tom or whomever, is there a parliamentary way that if the four of us agree to a recommendation, but we
No.
will only agree to it with the consent of the others?
Giving them the opportunity to call an additional meeting for further discussion.
No,
before-
not a meeting that they just say whether or not they're going to sign this piece of paper or not.
They would have to say that at a public meeting, unfortunately,
Okay.
or fortunately, depending on how you think of
Okay,
it.
here's how I think I'm gonna come down. I do not want to bind particularly elected officials who are part of this committee. I want to encourage them to participate in this committee. I think that we should send them a letter or a note specifically about this issue, about why their attendance is especially useful. I would consider, Heidi, if you would take the lead, signing a letter with you as a member of this committee. And Peter and Mary, you can decide to do that on your own or not. And can we take it from there? Is that sufficient, Tom?
Would the letter, would it be from the Penal Code Committee?
No.
Or would it be from members of the Penal Code Committee?
Who happen to be people?
So it'd be on Heidi's USC letterhead?
Or no letterhead at all? Sure, yeah. We would not claim to be, the Penal Code Committee. It would be Heidi, Michael Romano,
Right.
Stanford Law School and Committee of the Penal Code Committee.
I think then that has nothing to do with the Penal Code Committee in a way. So,
All right.
but I do want to repeat that. It's just there. This process is incredible. I think there's been nothing like it anywhere else in the country. And we kind of supposedly had something like it in California. It never actually, no one ever got reviewed because they kept extending how long you had to have done before repealing it. So I just don't want that also to get lost in the discussion as well.
I think the letter could express our extreme gratitude or, appreciation for this process. It's a fantastic opportunity. It's a fantastic opportunity that's long in coming, but I think it's also true that they should, someone shouldn't be excluded because they had a statutory rape at age 18.
Right.
And I think staying out of position to the political left of the proposal does not endanger it.
I just wanted to chime in to say that I understand that there's urgency with this particular provision, but that maybe there's room as well in the next year to look at other consequences related to 290 registration. We discussed one today that the 1170 offenses are going to prison, even for the non-serious, non-violent offenses, and the same considerations apply that it could be for a statutory rape, when a person was very young. So maybe there's room to address this issue more holistically at a later time as well.
Okay.
On that, what I don't know is how tiered registration as time goes on is going to affect some of those, like past registration people versus the people in here now. So it's all.
To Rick's point, it's a hairball. This is how I'm gonna decide. I'm gonna take some chair authority here and say that we are not going to vote on whether or not to write a letter from the committee for the reasons that we said. However, if anybody, and I would defer to Heidi, particularly because you do this more than anybody, would like to write a letter, I'd love to look at it and likely join it. I do think at a future meeting, however, hopefully when everybody's here, I'd like to at least address this type of scenario. Should this come up again, where the committee, or at least those members, those present at the committee seem to want to say something, but we are worried about binding those who are not present. And how should we as a committee feel about that? So that general provision, that general idea, I'd like to calendar for a later date. And for the purposes of this letter, let's keep it personal. Is that okay with everyone? Okay.
Right. And since it isn't a committee matter, the public open meeting rules wouldn't apply. So as long as it isn't, you know,
It's not a committee
we're
matter.
making that distinction.
Yes, we're making that distinction, and we'll make it clear in whatever is written, or I will, you know, for my part. And listen, I all of what you said, Tom, this is an incredible breakthrough, through no small part by the committee, through no small part by Heidi in particular, and Jennifer Schaefer and other people who are no longer part of the government. I think that, you know, a lot of people deserve credit here, and I want to support them. I am not meaning to undermine this proposal in any way. I only want it to be stronger and more inclusive.
All right, well, let's keep moving. Okay, so next update on something we don't think we should pursue, the coercion defense. So we've come back to this, I think, every meeting throughout this year. And the coercion defense is a complete defense to, currently it only applies to nonviolent offenses. And there was a bill this year that would have expanded that to all offenses that murdered and make it out of appropriations. It was AB 938 Banta. It also added something at staff suggestion that counsel could be appointed in vacatur motions based on a coercion defense in the post-conviction context. It doesn't matter. It didn't happen this year. And this is the third time in about 3 years there was an attempt to broaden the applicability of the coercion law. And, you know, and Rick and I have been working on this and thinking about it. There's really no data we can wrap our hands around, including really anecdotal data, to quite figure out how the law is working in the courts, where it might be due for some updates. And we just think we should not pursue anything further for a while. We should pause to give time for more development. All right. We will then do so. Okay, so now we are back to a proposal. And this is to require heightened judicial scrutiny of gender biased evidence. So, you know, this goes back to the meeting we had in April, where we heard about examples of really quite obviously prejudicial evidence being admitted to trials of women in particular that seem to play on gender bias stereotypes. So we proposed sort of a new balancing test in the evidence code, very similar to what we do for other types of evidence. And the most recent one the legislature passed had to do around creative expression, rap lyrics, where the court for evidence or argument, because we wouldn't limit it just to evidence, it'd also be argument that prosecutors or defense attorneys would make that would be likely to trigger gender bias. The court has to give special scrutiny to it and weigh the risk of reinforcing those stereotypes against the probative value of the evidence. So it's not automatically excluding everything and just having judges take a closer look. And we'd also add a post-conviction relief element to it if you can say your conviction was tainted by this otherwise. So, Rick, what have I left out about this?
You got it. I mean, we could get into the details of the specific evidence if anybody wants to that we're targeting, but I think you got the broad strokes.
Great. So we've returned to this one a few times throughout the year, so it probably seems pretty familiar, but we think it's baked and ready to go. All right, let's keep moving. Now we're going to return to our blanket 170.6 disqualification discussion. So there's 2 points here. The first is a bigger point, and it kind of mirrors the discussion we had about one of the RJ proposals. Should any restrictions on blanket disqualifications only apply to prosecutors or to all parties, aka defense attorneys? This is something that I think, Heidi, you brought up as a special point of concern a few times, and I think the committee hasn't quite come down with a final point of view on it one way or the other. So there's that question. Then we have some small tweaks from one of our panelists of the proposal, but the big question is this first one about prosecutors.
Before we even get to that, and I am curious what Heidi has to say. My understanding, I'm sorry if I either misremembered or didn't bring it up, that there's no statute that allows for blanket disqualification. It's just that the district attorney or the public defender announces, we are going to blanket every case before the Honorable Peter Espinoza, so don't even try it.
I think they actually file challenges because it's like two sentences. I think
Right, but
things,
they don't file, but they can't file one document that forever bars Peter
right,
S.
but
proposal.
they file one in every case, or you can do it orally,
Right, no, but that's my point. So how do you prevent them from doing 9 out of 10 cases or 2 out of 8? Like we're mostly going to bar.
Yeah.
So I pick on you, Peter, but not all the time, because nobody's saying, there's no law that's allowing them to press a button that says automatic disqualification. They're just saying they'll do it.
Well, I think there will always have to be some flexibility in the standard, but obviously doing it 9 out of 10 times, that's should still count. So the language, and this is actually sort of on the second point, is one of the suggestions we got that we think is a good one, is to say, prevents the judge from hearing substantially all of the docket. And there will probably have to be a little bit of litigation about that. But I think the real point of this is to kind of discourage attempts at some of the games that are currently being played in the first place. It won't rule all of them out, and I think there'll be sufficient guidance for courts to know what to do.
Got it.
And that's what Oregon, we're also basing this a lot on a law passed in Oregon, if you remember, and they seems to have worked well there. But on the prosecutor question.
So let me start with my concern, and then let me see if I can remember well enough how exactly how our proposal looks. But my concern is that when a judge has a criminal calendar, the district attorney is the party in nearly 100% of the cases. So, and they don't have an individual or entity client. They are, the people are their client. So they have this, there's a huge power differential. If a DA decides that they want to put that judge out of business, or that they don't want that judge to be on a criminal calendar anymore, they can essentially do that, not based on a client's preference, based on whatever concerns they have about getting, whether they're going to get a fair shake, or whether politically, I don't know, whatever concerns they have. The DA's office, it gives them a lot of power. I mean, I have heard judges say, well, I have to indulge the DA to some extent, not publicly, but I have to indulge them to some extent, because if they paper me, I'm back to, lemon law cases or whatever it is. I think that is not true in civil cases where this rule originated. It is not true for cases where there's a client, an individual client who is making the decision, who is, based on the advice or the information provided by counsel, who may be the public defender's office, who may represent 70% of the people in court. I don't know what the percentages are, but it's still that individual client saying, I don't want this judge, and I don't think this judge can be fair in my case. And so, I mean, I think the ideal proposal, and this may not be politically feasible, is that only parties with individual or entity clients have the 170.6 power, and government entities don't have that. Short of that, I would want to make sure that any proposal we recommend addresses that issue, because I don't know what Judge Espinoza, you will probably have a better idea of this. I don't know what percentage of cases a DA's office would have to paper before that judge gets moved to a different calendar, or gets moved out of the course, or feels the pressure. It feels the pressure from the district attorney's office, even just in little ways, So that's my big concern, and that's been a concern ever since I started state court practice and learned about this rule, which I think is a pretty unusual rule in a criminal case. It has seemed problematic to me, and I would want to be sure our proposal reflects that specific concern.
Well, let me just say that to preface my comments, in Los Angeles County, I would say it's probably closer to 80% of the cases that are represented by the public defender's office. The alternate public defender's office and 987 council are a smaller percentage. It would take quite a bit to put a judge out of business in a large county like Los Angeles, because there's so much work. moving between courtrooms. So if you have a judge papered by the DA in one case, what he's going to receive is the next case where the DA files a paper on another judge. They're just going to move cases back and forth. And I will say, having managed various courthouses, that I've experienced this problem with both sides of the aisle, quite frankly. And I couldn't say with any degree of certainty that it's more often the prosecutors than the defense. But it happens where one office or the other takes a dislike to the rulings, and stops going to that judge. I've been away for 10 years. So I don't know what the current climate is. I don't know how it's going. It sounds like this is a problem in smaller counties. I don't think it's a big problem in large counties, but I don't know. I know that wasn't very helpful, Heidi, but that's my thought.
It's a more than I, no, it is helpful. It is helpful.
There are 2 or 3 states that do say only essentially prosecutors can't file these types of challenges. The original California law from like the 30s said prosecutors couldn't do it. And in the case that the California Supreme Court is pending now on this, they just ordered briefing on this issue of whether there's some special sort of separation of powers issues when executive branch type officers, interfere with the assignment of judicial officers. And the data we got, which was very anecdotal, was that prosecutors probably do it more, but it's not overwhelming. And that was sort of statewide.
I still think there's the difference that prosecutors don't have an individual client with individual liberty, interests, and rights that they're protecting when they make that decision. It just, by virtue of the nature of who they answer to, it's more of a political decision. It just,
I agree with Heidi and all her points about the difference between a DA doing it and a defense attorney doing it. And I think that I would prefer the recommendation saying it's just barring prosecutors from doing it. I just fear the legislature is never going to do it with just, it's going to be hard to get it through saying just prosecutors. That's my pessimism on what I think should be done and what the reality is.
Right. I don't disagree. I'm just, going for.
So I would just want to make sure the author
supposed to be recommending what is optimal, what is fair.
That's what I agree, but
this is a tough. Is there some other middle ground? Could we say? I mean, I know it's ridiculous, and especially considering a county like Los Angeles, but think of it like juries, that you get a certain number of these chits that you can use over the course of a year.
It doesn't work for someone who's got an
defense attorney.
Yeah.
Or I just remember
prosecution has only a certain number of chits.
They're still gonna. I mean, I just remember like years ago, Sacramento County Public Defenders was doing it to a juvenile court judge, and they were just disregarding the law on when someone was sent to adult court or was something like that, where it was a fundamental thing. And so basically they eventually got that person retrained and then they were fine. But it was like disregarding some of, like someone who says no to whatever all the time because they don't like some change in the law or lets things, or there's been stuff where they let in evidence that we say you can't or vice versa. And I just think, so if there's only a certain amount, but this judge is doing it all the time on certain types of cases, that becomes problematic.
Yeah,
but I do.
Go
ahead. Yeah, sorry. I'm done.
I think to Mary's point, what do we mean when we say blanket challenge? Is it in 90% of DV cases or 90% of juvenile transfer cases? Because they're picking and choosing their issues. So it's sort of the same problem, even if a judge has an isolated, a blind spot, or perhaps there's a perception that the judge treats defendants of one race differently than defendants of another race. So it's those, in 90% of cases where the defendant is of a certain race. I mean, blanket, what does blanket mean? Is it just all cases? Because I don't think that's how it's used. I think it's used
agree.
more strategically and than that.
We tried to build that sort of broader definition and say it's, or a particular type of case or docket like that, because, and I think that's also where it comes up more in the bigger counties. It's like, here's the sort of the arraignment judge or the mental health court judge, and allowing either side to kind of kick that judge off. It's the same issue as doing it for all criminal cases, I think.
No,
I mean,
but I mean, Tom, that one judge with a criminal calendar, like they might be fine with that judge in a murder case, but not in a rape case. So it's 80% of all the rape cases that judge handles, or it's 80% of all the juvenile transfer cases that judge handles, or something like that. So it's not necessarily the topic of the court. It's by topics that are within a judge's calendar.
Yeah, I think that probably wouldn't quite raise these issues, because what we're hearing from the judges is like, when you have to sort of reassign the judge, which, even if it's 80% of rape cases, that's still going to be 3% or something like that of their overall. So it wouldn't quite cause that I think those bigger administration of justice issues that you'd see. But it's a good, I think some of this we can't predict every permutation, and maybe, Mike, part of the middle ground is also the proposal we have is basically the person making, or the party or entity making the blanket challenge just kind of needs to justify it, and if they can do that, then they can still do it. It would really just hopefully get rid of these challenges where it is just purely, you dared to suppress a gun in one case and now we're going to punish you. So if you can kind of make a case for it, I think our proposal would say, okay, that's fine, but you have to at least go through the trouble of doing it.
I think a lot of attorneys would say that undercuts the whole purpose of having this opportunity, because there are a lot of things you're not going to say about a judge.
Then so be it. Then you
But
can't.
I think that that's also, it's the DA who does it because you wouldn't let in the gun. I do think it can be the defense attorney will do it because this judge will never take a plea in a DV case ever, or whatever. Like, they're always going to reject pleas in a certain type of case, and I think that I just don't know that they're going to say that in open court. A defense attorney is going to say that. I don't know. I just think it's tricky.
Is there a way to, I understand the political problem of saying only the defense can do it. Is there a way to just say that only individuals can do it? Like, meaning the client has to actually?
It's the same thing.
Yeah.
I mean, I think our proposal should say only the defense can do it. I'm just saying we have to be realistic and what's going to probably happen in the legislature, and maybe have advice on how to narrow it or something would be my thought. I don't know. That's my.
Okay, that's a good sort of starting point. Okay, I think that we all well, I'm not going to speak for everybody, but I think that there seems to be rounding consensus that only defense should have it. The concern, I think, is if it becomes a bill that both sides will get it, is that worse than what we have now?
Yes. Well, for a defendant, it is. If you've got a judge who will never take a plea in a DV case, or who won't pay attention to the rules for adult courts, bringing a juvie to adult court.
So a law that passed that banned blanket challenges for either side is worse than what we have today.
Well, I guess if a DA is getting rid of quote unquote liberal judges all the time, judges that appear to be defense oriented, and then they feel the pressure that Heidi was saying, some judges will say, I don't know. I mean,
I think it's very, very county specific, because I asked that exact same question, and one county, the public defender was like, we would be better off with no blanket challenges, and another, they were like, you want to jump across the phone and strangle me since I suggested it. So
I've had that same experience. I feel very strongly about this in many different ways and have different opinions about it.
And I think our panelists, I remember Kathleen Gunaratna, public defender, was making a case that if it applied to defense counsel, they would have a better time of making the case for it, and they'd be better able to do that, so they could adjust.
Because let's remember, as you said, Heidi, California is, the number has shrunk over time of places that allow anything like this. Other states where I practice, this was not even like
Right.
something it's like still a little alien to me. So
Right.
I think it's not what is holding our system together. Let me put it that way. The ability to, kick judges off cases. But and that's why we sort of borrowed very heavily from what Oregon had done, because it wasn't a total ban. It was sort of a light regulation of it. And I think the idea really is like, you can't just say I 170.6 and then that's it and then done. You actually have to do a little bit more than that. And that hopefully that slowing down and having to know you have to go into court to say it will get rid of the worst uses of it.
How
Not
about
totally end it.
How about something even more milk toasty, meaning at the end of the year, the prosecution must list every time that they've papered a judge, and let them kind of stand by that. So we keep the current process. What I'm suggesting is keep the current proposal, but perhaps the public defender office and the prosecution office has to publish what they're doing. And maybe that curtails the practice and exposes a little bit of what's going on.
I don't think you could do that for the public defender's office because there's going to be client confidences that they'd have to review. I mean, what if you have a client who just says, he looks like my grandfather who used to beat me. I don't want him as my judge. Or he looked at me crossways, or he has mental health issues that are driving his decision. Or there's a racial, I mean, and I just think
let's let the DA do it, or maybe either side, but only if you've done it three or more times to the same judge. You don't have to report every single paper, but if the paper one judge 3 or more times, then you have to say what's going on.
But I mean, I don't know, is that necessary at the end of the year? Because once a judge keeps being papered on the same sort of cases, shouldn't the presiding judge have a discussion with the public defender or someone to be like, what's going on here? Because that's what I think happens in some counties. And so then it's like, there's a discussion, and that guy needs training again on domestic violence cases or whatever it is that they are annoyed about with him.
I totally agree, Mary, and that's what I'm trying to facilitate a little bit, with a little bit more sunshine than the presiding judge paying attention.
I suspect,
I don't know,
and I hate to say it, that data would be totally unreliable, because we went and watched sort of like arraignments in Sacramento, and the DA was doing it like every other case and just saying it, and it happened like 20 times in 2 hours or something like that, and that was just one courtroom one afternoon. So,
and then they would have to report that,
or what? And
nothing, or what? Then you get a piece of paper that at the end of the year, holy cow, the prosecution office really thinks this guy is unfair, and vice versa, the other side. That gives, as Mary said, the presiding judge some a little bit of data and a little bit of information, not to mention the public, not to mention the public defenders or the private defense lawyers who come in and say, if you're a private defense lawyer and the public defender has blanket challenge ex-judge because they're the worst, you might want to know that.
I think except maybe in LA but I think in a lot of counties, they all know what the other one's doing. It's a pretty incestuous little world, has been my observation of defense attorneys, judges, and public. They all know what the other ones are doing. They all know the I don't know. That's been my observation, but
I would certainly, let me put it this way. I would certainly want to know, as somebody who practices in many jurisdictions and is not a public defender, I would love to see the data on a judge. Oh, wow, this judge has been papered 100 times by the prosecution.
Yeah.
Well, so a data collection requirement that Mary will correct me if I'm wrong, but that'll come back with a big cost on it, probably higher than what this process would be, honestly.
Oh yeah.
I know we're
And
not.
it's a mandate and it's huge. I mean, I think, yeah. I guess I mean, I think the real question is a blanket ban on both sides, if that's ultimately what we, pessimistically suggest the legislature will do. Is that better for people or not? And I don't know.
I mean, we thought a lot about this, and at least me and Joy. I don't want to totally speak for Joy, but I think it is because
It is what?
better to have limiting the practice for both sides, because it's just inappropriate. Like, if you think the judge is not following the law, there's a host of mechanisms. They often a pain in the butt, but that's what the rest of the country has managed to do. And then you can also have these informal mechanisms as well. And I do suspect that the chilling effect is probably, you are fearing more of prosecutors than the defense community. And if there's a chilling effect, it probably leads towards that direction, even if the challenges are not totally skewed that way. And in writing it up, we could say, these harms seem especially apparent when a prosecutor does it, and that's where it should be limited. But we just want to kind of give ourselves, I think, the flexibility, if there was a bill, to say this is still implementing the recommendation, even if it isn't limited to prosecutors, because otherwise we will lose control of what happens.
Okay, here's how I propose.
One more thing to think about, Tom. When you say that, when you're defining what a blanket ban is, if you go with like 80% or whatever, however you define it, like once the public defender's office papers the judge in a certain number of cases, defendant number 271, then they're just out of luck. They don't have the opportunity to paper that judge because they're over the 80%. Like, we have to make sure that individual defendants still have the same rights as every other defendant and the rights they're entitled to. So I want to think really carefully about how we phrase it.
I think that's
I think that's been part of how we've written it up, that we don't intend to touch truly individualized challenges. Now, how that sort of cashes out in legislative language, we don't, we can figure that out maybe as we go. But that's sort of been built in, or we've tried to build it into the proposal, which is like, this is just these sort of coordinated efforts that seem inappropriate, not like, one-off or less frequent.
All right, here's what I propose we do. I think that we tentatively move on with a tentative proposal to prohibit the practice by prosecutors. Think about it some more before we make a final decision.
Yeah, though I will say we've been thinking about it more for 2 or 3 meetings. So I wonder,
we're gonna have to make a final call, and like, we don't need to make the final call today, is what I'm trying to say.
Absolutely not. Yes, it's very easy. It's a paragraph in the report it's easy to adjust that way. But I will say we're kind of having the same discussion multiple times, which is how it works sometimes. But I don't know if we'll have a breakthrough next time either. I hope we do.
Well, yeah.
All right, so fair enough. And then here's the actual text of the proposal. And what you'll see in bold here is what has changed from last time. I'm sure you all have tracked it word by word, but this is mostly in response to what Judge Dan McGuire, who was recently the presiding judge of Yolo County, he came and spoke to the committee. He's leading a working group of the California Judges Association on this. He suggested adding these things. Except for the last one, which came from someone else, but that's not significant, I think. And the first bullet is about sort of defining the blanket. So he thought it was a great idea to add substantially in there, so it isn't 100%, that there is some wiggle room to get to the 85, 80%, whatever it's going to be. Obviously, I don't think we should put a percentage in there, but to indicate that it doesn't have to be literally every single case. And then again, the practice would be the challenge judge or the presiding judge can order a hearing into it that's heard by a judge from another county. And the party making the blanket challenge has to establish a reasonable good faith belief with particularized facts the judge is prejudiced against them. And the one thing we'd add here, which I think is inherent, but good to specify that the good faith belief can't be based on, race, ethnicity, gender, or these other categories that are, defined in civil procedure 231.7a, which is the better than Batson law that defined all the sort of protected classes.
Wait, why can't it be based if we think that this judge is prejudiced against Black people?
Well, not based if the judge is Black. So there is an
Oh,
example
okay,
in
well,
Yolo
let's
County, right,
let's specify that.
where that's right. So we can add in of the judge in there. But this happened in Yolo County where, anyway, it's a more live issue than you would suspect, I think.
I mean, I still don't understand how PD's office is going to do this. Like, are they going to give the good faith belief of each of their clients who decided they wanted to paper the judge and disclose that? Like,
I guess I push back a little bit that it's the client really making the decision. I mean, I think it's obviously going to be very attorney driven a lot of the
Could
time.
be based on attorney information and advice, but ultimately, I think that's a client decision. I don't think an attorney can file that without the client's buy-in.
We could put in a business. I sort of agree that even if a blanket challenge is filed, that you can always retract it in a particular case.
No, I'm asking when you establish the good faith belief, is it the client's good faith belief who made the decision? Is it the attorney? It's so different.
I think it's the attorney.
It's because that's part of 170.6 already. Yeah. That the attorney's filing something saying I have a good faith belief that the judge is prejudiced, signed, Mike Romano Esquire. So I think it is the attorney affirming that most of the time.
And I think that's better, honestly, than the client saying
yeah.
that.
I agree. Okay. All right.
But that was not, the public defenders who spoke to about this, they didn't raise that as a concern, but maybe I can raise that again with them and say, have you guys really thought about this? Okay, so we will write this up as indicated here. I think we'll write it up as applying only to prosecutors. And then if we decide to remove that at the next meeting, easy enough to do.
Yeah.
Okay, great. Well, that brings us basically to the end. So we're almost done by 3, Hattie. I was, maybe I should have.
Now I have a half an hour before my next meeting. So that's
okay, perfect. So there are 2 other recommendations that we haven't gone into today that we discussed at previous meetings. I think there was consensus on them. Very briefly, they were to allow habeas corpus relief and hopefully release for some for people convicted of failure to protect murder, that the law seems to have been changed by this recent California Supreme Court case, People against Brittany Collins, basically to slightly expand, habeas corpus relief to say, hey, I wouldn't be convicted today under these new rules. And the second is to modernize the statutory definition of self-defense in IPV cases, intimate partner violence, domestic violence cases, and specifically to say in those types of cases, the imminence requirement is not a requirement, it's a factor the jury can consider. And there's also, you don't have to show you acted from fear alone, that there can be more of a mix of motivations. So they would become not prerequisites to the defense, but something a jury can consider when determining whether the defendant has proved it sufficiently.
On the first point, I think I raised this last time and I forget what the answer is. Have we considered some sort of clarification of all the Estrada nonsense and just that everything should be applied retroactively, barring some extraordinary circumstance?
We did, and I think it becomes quite complex. And I think the consensus after that discussion was let's continue thinking about that, but not for now, because it all comes down to like, how do you define what a change in the law is, and where do you draw that line? Because is it truly every possible thing? People can go back for all times, as many times as they want, and it's really that line drawing which current law tries to do. But I will also say the legislature has been, more things have been retroactively applied specifically than I think before. So there is that trend happening in the legislature.
Right, and I suppose AB 600 does a lot of the work here, huh?
Right, it's a great mechanism for it, but as we know, it's very contingent on many things. But yeah, and that's a great example. Okay, so what we have to do now is public comment before the committee makes a decision, and I'll preview. This is a slide of everything all together. It includes the prima facie thing. So maybe I'll update this during public comment to get that off. And then we can just make sure or the committee needs to vote and say this is what staff should write up. We have to do that after public comment. So public comment now, Mike, is this a good
Sure.
moment to do it?
And we have to have another public comment after?
No,
Okay, this is public comment time.
this is it. Yeah.
And hello, to our fans. Thank you for being here. As you can see, we're doing a lot of sort of parliamentary work today, or to try to get our recommendations out. So please do try to keep your comments to the matters at hand. And if not, make them especially brief if you might, please. Thank you. All right. If you're interested in public comment, please raise your hand. Based on the number of people in the queue, I'll decide how long everybody has to make that comment.
We've got one hand up, and I anticipate that'll be the only hand we have. So why don't we get started with Hovanas Tenoyan.
Okay, Havanas, you have 2 minutes.
Hello there. My name is Hovanas Tenoyan. I'm from Burbank, California, and also a UC Berkeley graduate. I want to thank everyone, the bar, the bench, and the community for getting together to revise our penal code in California. The topic I wanted to bring up, and I emailed Mr. Nozovic about this briefly, is for crime victims and crime victim compensation and crime victim services. Where does the penal code fall into that? Penal code 13835 and 0.5, back in 1983 and 1996, these is the statute that gives the intent and the services that crime victims get, whether it's mandatory services or optional services. So I definitely want to take a second look at these statutes, see how we can modernize them and update them for recent times, because decades have passed. Think of how society has changed, how technology has changed, how our understanding for both victims and for perpetrators has evolved. So, and I noticed over this meeting, I've been listening to it through the whole day, and I really love everyone's incredible comments and analyses. So I thought maybe I could share a little bit of my own suggestions for improvements. When we think of the crime victim system overall, there are some parallels to the bankruptcy system. So if you think of like the crime victim advocates, they're kind of like the trustees. They protect crime victims the same way trustees protect creditors. You think of the U.S. trustee, they're kind of like the attorney general, the U.S. attorney. So if someone is not worthy of a bankruptcy discharge, it's the same way with crime victim services and compensation. We only really want to give them to the honest but unfortunate crime victim who had no part in the victimization that they experienced. So that's a suggestion and a inspiration you can take. And also writ reform. So every time there's a crime victim compensation denial, every time services are refused by the county, for example, all of that would go to a writ judge. And over here in Los Angeles County, for example, we only have 3 writ judges. So imagine the overwhelming burden and workload that they have on their plates: cities, counties, state agencies. It all funnels through them. So crime victims, for example, they might get lost through the cracks because you might have judges who are very process oriented. They're very well versed in the law.
Mr. Tenoyan, we really do appreciate your thoughtfulness, and that you were, here for much of the conversation earlier today. If you have it's much, I think, more effective to email suggestions, substantive suggestions to the committee staff. But we do appreciate your thoughtfulness. I truly do. So thank you for trying.
Is the comment done? Or
Yeah. I'm sorry. We had 2 minutes. If you have one last quick thing to say, we're happy.
Just dates. June 18, Joint Legislative Audit Committee. Please reach out to them. They approved an audit. October 24, Judicial Council meeting. Reach out to them for any advocacy.
Okay.
November 20, CalVCB meeting.
Mr. Tenoyan, I'm sorry. This isn't.
Okay, that's it. I'm so sorry. Thank you so much, everyone.
Just email us. It's much more effective and helpful if you have this in writing. So email us, and we'll do our best to respond.
Okay.
Thank you. Are there any other members who have raised hands?
Nope.
Okay, doke. So can we take a vote?
Yes. Well, I realized, Mike, that we didn't circle back to the serious and violent and the victims discussions, including DA Dow's discussion earlier today. Maybe there we kind of already feel like what we need to do about those, but I wonder if we should just make sure we speak about those in particular. So let me
All right, let's start with the easier one, in my opinion, which is the serious and violent list. Basically, as I understand the proposal, is that we take 3 crimes off the serious and violent, or this, is it just the serious list?
it's a mix. It'd be
So 3 crimes.
robbery off the violent list, but yeah.
Right. And replace them with 3 that most people think, and I you know, in a fair mind would agree should be on the list. Any thoughts on that? With robbery being the complicated one, I think that we still need to work at, and I don't want to get into it too deep here, except to say that
Right.
we should work on it some more. Okay. And for the victims,
Well, there was the subtractions and the additions to the list
Yeah,
too,
that-
but I assume, okay.
that's what I was covering both.
I thought you just mentioned the subtractions. Apologies. Right. And then require counties to use the child advocacy centers. We heard about that from Ms. Fleming. 44 counties have them. But
My only reservation there would be if there's small counties that feel overburdened and they can coordinate with neighboring counties, I would allow something like that.
yeah, definitely. And then we had the victim's right to be heard on protective orders. You know, DA Dow says he thinks this is already a right, but agreed, I think, that it wasn't laid out in the penal code in a way that it could be, and perhaps some guidance on what how that can work.
And
I
then
just want to make sure that protective orders didn't get delayed. You know, protective orders that are issued at arraignment weren't delayed for the input, but I don't know how to exactly to accomplish that, but I heard 2 things on that. I heard that they often get issued before the victims are even aware of the process, which seems like a good thing generally, but that they could be amended or changed or updated once the victim has input. But you wouldn't want there not to be a protective order for
Right.
a period of time.
I think that's a great point.
and
And then DA Dow's colloquy at the guilty plea about notice of victims' rights is not on here. Is that something we want to include?
yes, I want to include it, and I suggest it for serious and violent felonies.
Okay. Great. Let me just update this list. And I'll specify.
With the provision that we discussed that no incarceration is extended as
Right. The formatting is, something has happened.
we trust you.
Yeah, there we go. And it's serious and violent cases, right? That's what you said, Mike?
That's my proposal.
Okay. Great. Anyone else have any other thoughts about that? All right.
Victim/survivor instead of just victim, or it's we try.
I will say one of the reasons why I want to try to suggest this is apparently it's the number, if not the number one, it's a number one priority of the District Attorneys Association. I think that they're important players here, and if there's ways that we can accommodate their input, that we all, I'd like to, and it seems reasonable to me. So that's why I'm forwarding it.
I think that's a great instinct. Okay, so I guess a formal vote or something, or somebody make a motion, Mike. Oh,
Yeah,
whatever.
so I guess I move to make this our list of recommendations for the 2025 annual report. Everybody knows, however, that those recommendations will be refined in the report that is to come, and that we will vote on those final recommendations, meaning the final version of the recommendations, including all of the details in the report at a future meeting. Does that satisfy the Tom?
Yes.
Yeah, okay, good. So I move, that's my motion. Can I have a second?
I'll second.
All right, and anyone, let's all affirmatively, I vote to approve these as our recommendations.
Aye.
Great. Thank you all. This is, another long day, and it really is in almost a culmination of a year's worth of work. Look at all these recommendations and how hard we thought about every little detail already. And, you know, Tom, Rick, and Joy obviously do the heavy lifting here. So thank you, everybody. Thank you for your time. I do hope that we can find a time that we can all get together, meaning the entire committee, especially for our final vote. I would love that, Tom, if we can make that, even if we have to make it a very short meeting. And also perhaps to recognize some of the procedural question that we ran in today about the tight timeline on the recommendation to the BPH. Okay,
Great. Yeah. Next meeting is November 21st, I believe, Friday before Thanksgiving. And it'll just be approve the report, talk a little bit about topics for next year and maybe some of these this procedural issue.
Yeah, can I say this? Cut me off if I'm not supposed to, Tom. I've been talking with staff about topics for next year. I know staff has also been independently thinking of topics for next year. This is the time, if there are topics to be thought about, Peter, Mary, and Heidi. We could, unfortunately, the four of us cannot talk about them outside of this meeting for public meeting request purposes. That's why I haven't called you and asked what your thoughts are, but here I am. So I am curious what your thoughts are. Email them to Tom, Rick, and Joy.
Well, that probably would not be best practice, unfortunately. We'd have to have the discussion in public.
They can't just say, I want to discuss X, and then you put it on the agenda as.
Not if we're doing it to avoid having the discussion in public.
No, we're not avoiding anything. It's just so that that all the ideas can get to you.
I think it'd be better not to do that. Let me put it that way.
So okay. So the only way, okay, with that in mind, the only way that you can add things to our possible agenda next year is to bring them at our next hearing. Is that right? Is that what you're saying, Tom?
Yes.
Homework.
Or you can mention things now too that we can make sure to add to our list. But yes.
Sorry to homework, but just so you know, it was Tom's fault, not mine. All right, we have, in all seriousness, we have been giving this a lot of thought. Let me just plant a couple seeds in your head, not necessarily topics, but we've thought about perhaps taking over just one topic for the whole year, rather than jumping around to all sorts of different ones, because obviously some topics can go deep, juvenile justice, conditions of confinement. I forget what some of the other ones that we've thought about, but there are some sort of broad issues that could take up our entire year. So we've thought about that. We haven't committed to it at all, but think big, think creatively. I know, Peter, you've been here since day one, but Mary and Heidi, you know, we'd love your thoughts and suggestions, and yours too, Peter, of course, even though you've been here all. All right. Thank you all. Have a good evening and a good weekend. I hope to see you all soon. And goodbye. Thank you, Tom, Rick, Joy.